So I'll start with the concept of may you live in interesting times. I mean, this is a kind of a curse or what you can call it. It's a Chinese proverb, or I mean, that's usually said. It's better to live uh, a life of a dog in times of tranquility than a human in times of chaos. If I put in a nutshell what transpires to be information technology, I would actually go into the facets of what, as an individual, when I was young, actually I had to go through. So, it's pretty overwhelming when I see the whole progress which has transpired from an 8-bit computing to 64-bit computing, right from the days of ZX Spectrum, Commodore, to what we have at present, 5G and maybe down the line 6G. So it's kind of an augmentation which is just phenomenal. So you started with something called text. And when I say text, I usually talk about standalone machines. And further down the line, I mean, I come from the decades of 80s. And when you really look back during 60s and 70s, that's during the period when you had something like ENIAC and mainframes and, the whole facet. And it was much more of text, concentrating much more on text. And now, when you are actually, say, in the 21st century, it's much more actually we are concentrating on videos and broadband technology and things like that. So when I talk about 8-bit computing to 64-bit, I'm talking about binary, and now maybe down the future to quantum computing. So we're talking about ENIACs to handhelds. Um, I still remember the days actually, ZX Spectrum. I mean, it was uh, kind of a 8-bit computer which had an input device, which was a keyboard, and that was a huge leap during that period of time. And we had, input device, we had a cassette recorder in which actually the magnetic tape used to actually act as an input system. So if we wanted to actually play a short game, it used to take around 15 minutes to actually load that game into ZX Spectrum, and we could play that. We could turn that machine into a small rudimentary drum machine. It was a huge, technological leap during that period of time. I mean, today's Gen Z would find it very, amusing when I say that we could convert this to that. Now you have all these kind of softwares like Fruity Loops and things like that, where you can actually, make your own music video, music. You can make it on a computer, so you can actually turn it into a whole console. So, I mean, later on, it is gamers. When I talk about gaming, I'm talking about console gaming. I'm not talking about mobile gaming. So, and I'm talking about things like overclocking and the ethos of hackers, which right now what it is, I mean, it used to be a kind of a lone wolf kind of a person who would, you know, be so interested in actually going into the rudimentaries of the technology which was there behind, not the term what we use hackers right now. Don't kindly confuse hackers with crackers. Okay, so these are two different facets. So hackers during 80s was something what petrol heads were during 50s and 60s. So now when you have this kind of information amplification which is taking place, I mean, in a sense, I mean, previously when you used to gossip, it used to be only among friends. Now when you gossip on social media, it's for the world at large to see. So it has its own kind of implications which are there, and kind of mitigation exercise which we need to take right now. So we are still into that romantic era when we thought that individuals are free to, collate information, try to actually have this kind of information democratization, which would help people to actually augment their knowledge processes, augment communication, getting in touch with people at large. But now when we actually really look to things what is panning out, it's pretty confusing, daunting actually, in which actually everybody seems to be in kind of individual silos. So what role law has to play when it comes to actually, regulating the flow of information? So that is paramount when we try to say those things, understanding information technology law. So state itself right now, I mean, some of the states, I'm not talking about all the states. States, when I use the word state, I mean nation states. So nation states themselves have taken over the role of crackers. They themselves are actually, having this kind of concentrated attacks on different critical infrastructures. So it's kind of a cyber attack which is taking place. And even data right now, it's kind of, you have this concept of data weaponization, in which actually people are more or less, actually nation states are ring fencing data, having these kind of localization laws in which actually when data itself is a currency, you are trying to ring fence it. You're trying to create kind of barriers in which actually there would not be data flows. And this itself is not a huge, it's kind of taking us regressing it. What concepts we used to have during the 60s, during the flower era, or during the 80s, in which we really believed in this kind of that information is going to solve and resolve a lot of issues which are there at large in the world. So when I look at information technology law at present, I mean the Information Technology Act 2000, which is an Indian law. I think that law is meant for, or was devised, or was done during a kind of an era in which it used to be standalone machines. We had internet later on, but it was actually not uh, the internet what we know at present. It was something which was meant, or which was dial-up modems. I mean, it's a different beast altogether when you talk about dial-up modems. It's not what uh, is right now 24 into 7 connectivity. So this whole approach right now is that we are in a constant state of flux. New laws are being devised, new rules are being formulated, uh, and it's not something, I mean, the law is trying to catch up with the kind of technological augmentation which is taking place in the real world. We are doing a catch-up act, and especially India, it's I don't know. I mean, we say that information is power, information is key. Or if you have read about Alvin Toffler, or you have seen the movie called Sneakers, I think so. Cosmo, the guy which is played by Ben Kingsley, he said, information is everything. Information is the key to power. Information is what actually, people are more interested in how you think, how you react, what are going to be your choices, and the person or the state or the actors which control that information would be holding the key to the future, and that's paramount. So it's very important to understand information technology in that context, that information is the most important thing, and information is going to play a very pivotal role in which actually politics and most of the social constructs which we understand in society are going to play a very, very secondary role, and information is going to be the most important thing which is going to be there. So when you look at information technology law, what do we actually understand by that? The law refers to a kind of a framework that governs the use, access, and management of information technology. So what does it actually entail? It basically it encompasses laws, regulations, policies that address various aspects of technology related activities, and that includes digital transactions, cybersecurity, intellectual property, and privacy. So when you talk about the key components which plays a very important role, would be, I mean, that was the reason in which actually Information Technology Act was actually devised. It was there to, the requirements for electronic transactions and online commerce was pivotal during that period of time. So digital transactions and e-commerce plays a major role. Intellectual property rights. Now, this is another facet which comes to, kind of creations or creations of the mind, inventions, literary and artistic works, symbols, names, images, and designs used in commerce. That becomes very important. The next with and so basically protection of intellectual property rights is very important. Data protection and privacy, that's another facet which needs to be highlighted. Cybersecurity, and when you talk about cybersecurity, you talk about safeguarding computer systems, networks, and data from various cyber threats. I mean that you're talking about cybercrime, you're talking about data breaches, and you're talking about, the kind of standards which needs to be, maintained to protect cyber infrastructure. Regulations of telecommunications. So this is another facet which is actually, the kind of spectrum allocation, or on which you have seen that, right from the days of 2G to 5G. Actually, 2G was actually GPRS if you come from that era, and right now what do you have 5G? So 24/7 connectivity, and the kind of liability which is there in the cyberspace. So the legal responsibility for actions conducted online. So this is what it is. So liability of internet service providers, liability for user-generated content, and kind of a tort liability in cyberspace. So information technology law plays a very, very crucial role in regulating and facilitating in the use of technology in various aspects of society. So when you say that, what is information technology law? So it should basically, it should balance innovation and technological advancement with legal protections for individuals and businesses. So when we talk about information technology law, we have to understand the importance of IT law in the digital age. So in the modern era, the proliferation of technology has transferred nearly every facet or aspects of our life. So since the advent of digital age, when I would say that the advent of digital age was during the World War II, when you actually came out with ENIAC and, DRDO, when they came out with most of the mainframes. So it started, the whole concept of started with invention of transistors, and later on to semiconductors. So, and right now in the 21st century, which we always call it, it's a digital century, or the digital age, has become, it's the information technology law is increasingly vital in, shaping the legal framework that would govern the use, access, and management of information technology. So basically the law plays a very pivotal role. So when I say law, it's laws. We don't have actually a single facet information technology law. There are various interlinks which are there, whether in terms of policies, whether in terms of actually kind of rule-making mechanism which is there, and other acts which are actually coming into foray, or which will be down the line and will be replaced by something else. So IT law plays a very pivotal role in safeguarding individual rights and privacy in the digital realm. So when as technology is advancing, so is the risk associated with privacy breaches and unauthorized access to personal data. So IT law basically will provide essential protections, ensuring that individuals have control over their personal information and are shielded from intrusive practices. So various laws, such as what was there, what Europe has devised, General Data Protection Regulation, which is there in the European Union, or when we talk about consumer privacy, what law comes to mind is a California Consumer Privacy Act in the United States. And the approach which we are going to take is global. Let's not actually have this kind of a silo mechanism where we only talk about a national law, information technology law, because to understand technology law, we have to also take a very comparative approach. We cannot have this kind of a unitary approach in which we actually only look at our law and we think that, this is what we always do a catch up to other laws which are happening in different continents and different nations. So it's very important to understand other laws which are there in other nations. Okay. So basically, most of the laws which are there in the West are quite stringent when it comes to requirements for collection, processing, and storage of personal data. And thus, it basically what it does is actually reinforces individual privacy rights. So IT law, when you talk about information technology law, in most of the areas is instrumental in regulating digital transactions and internet electronic commerce, or, basically it's, what do you call it, globalization 2.0. Okay, so you had globalization 1.0 was during the late 19th century onwards until we actually got our independence. But this is like globalization 2.0, where actually, again, digital commerce is playing a very pivotal role. So it is with the right, and especially when you look at this whole kind of concept of, going back to online shopping and digital payments, it is very, very crucial, to understand, what basically entails for consumers or individuals. So we are talking about electronic electronic contracts, digital signatures, consumer rights in online transactions. They are all addressed by information technology law. Okay. So basically, it provides a kind of a legal certainty and ensures fair practices. So information technology law, basically, it will foster a kind of a trust and confidence in electronic commerce, because trust is paramount when it comes to commercial transactions. Without trust, it's not possible to actually delve into this facet of information technology. So it basically facilitates economic growth and innovation. So when you look at the second aspect, which I have already highlighted, is the protection of intellectual property rights. Now, since you are actually in the digital realm, you're talking about, uh, it's very easy to copy and distribute digital content. I mean, when you talk about music, you talk about software, you talk about databases, you even talk about movies or videos. Everything it's very easy to actually kind of copy and distribute digital content, and it's not something which was very similar to what we had during the 80s, when you had this magnetic tape or a cassette, which you used to call, and you could basically what do you call it, the quality of the recording would go down once you actually do it. And that's not what happens when you actually are copying digital content and distribute it. The quality does not suffer, actually it remains the same. So it's very, very important actually when you talk about intellectual property rights. You're talking about much more concentrating on copyrights when you talk about information technology. So infringement and piracy plays a major role. So IT law or information technology law has to address these challenges of piracy, of infringement, by providing certain legal mechanisms to protect the creations of the mind, which includes literary works, artistic creations, inventions, trademarks. So IT law ensures that creators' rights are respected, they are incentivized, basically for their creativity. And another aspect which comes is cybersecurity and data protection. Uh, by promoting cybersecurity best practices, I mean, this is very important. Actually, law alone would not entail that it would give you 100% blanket protection. You require to have certain standard operating procedures. You require certain best practices, and also you have to impose penalties for non-compliance of information technology law, or and basically IT law and certain SOPs would help you to mitigate the risk which is associated with cyber attacks, data breaches, and it safeguards both individuals and businesses. So, and IT law also governs certain emerging technologies. Now, what are these emerging technologies? I think so. I've shared certain facets of artificial intelligence in my previous lecture, uh, and blockchain, cryptocurrencies. Blockchain is one technology. Cryptocurrency is one part of blockchain technology. It's one of the applications, actually, which the right word is that. And IoTs, they have the potentiality to revolutionize industries and transform the way we live and work. So, but then again, there are challenges when it comes to actually artificial intelligence. It comes down to algorithmic biases, data privacy, liability for autonomous systems. So these are something IT law addresses. It also addresses the kind of an interconnected world which we are living in. So basically, as the topic says, I mean, basically you'll be charting the legal landscape. So it basically, information technology law navigates complex jurisdictional issues and facilitates international cooperation. So information technology is basically, the law is basically important in the digital age, and it serves as a legal foundation for a digitized society, providing essential protections, promoting innovation, ensuring accountability. So it basically acts from safeguarding privacy and regulating electronic commerce to protecting IP, intellectual property, and addressing cybersecurity threats. So IT law plays a multifaceted role, in shaping the digital landscape. So as the technology will keep on evolving, the role of IT law will become even more crucial in navigating, the complex legal and ethical challenges of the digital age. So when we talk about information technology, we talk about evolution of information technology law. So what do you mean by evolution of information technology law? I mean, we are not going to go into the historical facets of actually how Charles Babbage invented computer or what really transpired. We are talking about evolution information technology law. So it is a fascinating journey. I mean, so rapid advancement of technology way back 50s, 60s, 70s, and it had a very, very profound impact on society. Information technology is there. So so the key milestones which I can highlight is, the early foundations. So when you talk about early foundations, we are talking about mainly 70s and 80s. So as you know, I mean, kind of computers started becoming more and more relevant in businesses, and in the West, actually in the 70s and 80s, personal computing actually played a major role. So you had this kind of mainframe, mini computers, and personal computers. So this actually really transpired. So basically, computers became more and more relevant in businesses and government. So legal frameworks began to take shape to address those challenges. Once actually it became more computers or information technology started becoming more and more actually democratized and played a major role. So thing in mind, what comes to the next is the emergence of uh, kind of legislation which looks into the aspect of cybercrime. I mean the word cyber, actually I have said it, actually it is kind of a thing which is much more into William Gibson neuromancer. That's how the whole term involved cyberspace, that whole concept. So will not go down to semantics, we'll actually stick to that. So the very first thing which comes to mind is actually the Computer Fraud and Abuse Act 1986, basically in United States. So that was the first comprehensive laws which aimed at addressing computer-related crimes. So it criminalized unauthorized access to computer systems and laid the groundwork for subsequent cybercrime all around the world. So again, which comes into foray is once you started actually going into this facet of text to audio to video, there was an expansion of intellectual property rights. I mean, previously it used to be only text. So you had HTTP, and I still remember the days actually. I think so it was 95, 96, and actually when internet came into India, and this whole concept of it was still actually pre-audio era or pre-video era, in which actually text played a major role, and you had this kind of thing in which you had a dial-up modem and it used to take a lot of time, and uh, but still, it was wonderful. Actually, it was something which was really mounting to some leapfrogging in technology, which was not there previously. It used to be standalone machines. So anyway, so once that came into, we started leap forwarding from text to audio and audio to video. So as things devised from dial-up modems to uh, DSL, digital subscriber lines, and now you have 5G and 4G and all these facets. So when it started leapfrogging from text to audio, the Digital Millennium Copyright Act of 1998, that was a landmark piece of legislation that addressed those issues in the digital age. So it introduced new provisions to protect digital content and criminalize the circumvention of technology measures used to protect copyrighted works. So then there was the evolution of data protection laws. And data protection laws, one which comes to mind is the European Union's Data Protection Directive of 1995, was one of the earliest examples of comprehensive data protection legislation, which is basically the foundation for the data protection regulation GDPR in 2018. So, which is considered to be the most stringent data protection laws to date. And now what uh, Digital Personal Data Protection Act 2024, which we are going to have very soon, is going to be based on that. So not as stringent as what GDPR is, but quite stringent. So globalization and cross-border regulation. This is one thing in which actually international treaties and agreements such as the Council of Europe's Convention on Cybercrime, also known as the Budapest Convention, where it established to address those cross-border cybercrime and facilitate cooperation among countries in combating cyber threats. So as technology continued to evolve, IT law had to adapt to new challenges posed by emerging technologies. So again, I mean, it comes to forays. artificial intelligence, blockchain, Internet of Things. So keeping those facets in mind, the evolution of information technology law has been, kind of a continuous adaptation. You have to adapt to the changing technological landscape. So basically, it used to be combating cybercrime to the development of comprehensive data protection laws and regulations. So, and IT law has played a very crucial role in shaping the legal framework that governs technology related activities, and it will keep on actually, because new challenges are ensuring that legal protections keep pace with technological innovation. This is very important. So we talked about Data Protection Act of Directive of 1995. Then there is a Children's Online Protection Act called COPA that was in 1998. So the Children's Online Privacy Protection Act in 1998 in the United States was, basically enacted to protect the privacy of children under the age of 13. So the kind of, consent mechanism which is there. So to protect children whose age is below 13. So that was the reason for this enactment of this law. And so it basically required website operators to obtain verifiable parental consent. So before collecting personal information from children, and impose a strict limitation on how this information can be used or disclosed. So another is the Electronic Signatures in Global and National Commerce Act, e-Sign 2000. So that's related to electronic signatures. Then the General Data Protection Regulation, GDPR 2018. In the European, it's EU. It's an EU act in which actually it represents one of the significant developments in data protection law. And GDPR, not only does it strengthen individual rights regarding their personal data and imposes strict obligations on organizations, which we now have, in the new act, in which actually we call them data fiduciaries. So basically, or data collectors, which is the right term to use. So it imposes strict obligations on organizations that collect, process, and store personal data. It basically GDPR introduces requirements such as data breach notifications, data protection impact assessments, right to be forgotten. Significantly, it raises the bar for data protection globally. When you talk about information technology law, basically entails certain significant advancements in the development of information technology, and it addresses, in a nutshell, issues such as cybersecurity, information, data protection, privacy, intellectual property rights. So again, it has to keep on adopting. It has to keep on, the legal frameworks have to keep on being in the same wavelength, or they have to keep pace with technological advancements and provide adequate protections for individuals, businesses, and society as a whole. So this is one aspect when I say information technology law. So what are the key legal concepts? So intellectual property rights. This is as I already highlighted that infringement and piracy is a major concern when it comes to information technology. So an overview of copyrights, which is there. So basically, that's kind of it's a multifaceted approach. When we look at information technology law, it's not actually an information technology law on its own as a standalone law. It has to actually work in tandem with intellectual property laws which are applicable in nation states. So when it look at India, it's basically the Copyright Act. And what does the Copyright Act protect? It protects original literary, artistic, musical, and dramatic works. That includes software programs, databases, websites, and multimedia content. So copyright, basically, it's an automatic protection for computer programs from the moment they are created and they are fixed in a tangible form. The most important thing is actually fixation in a tangible form. While registration is not mandatory for copyrights, but what it always acts as an additional evidence of ownership and facilitates enforcement. Okay, so duration of copyright for computer programs lasts for a lifetime, and of the author plus 60 years. Now, patents is another thing which comes into it. Talks about novel and inventive technologies, inventions that would entail not exactly a software on its own as a standalone software, but in conjunction with an hardware which is actually inventive, which is novel. And so basically algorithms and those facets are not actually given protection under Patents Act. So software per se is not patentable, but software along with a hardware device, which is solely required for the functioning of that device, can be patentable. So technical innovations which is attached to those device or novel applications of software may be patented. Okay. So the duration of a patent in India is for a period of 20 years from the date of filing of the application. Now, trademarks is another thing which is important, because when it comes to e-commerce, logos, symbols, slogans associated with intellectual technology products, or even local consumer products which are there. So basically, what is trademark? Trademarks are basically they are kind of logos, word marks. But what is actually the eligibility for trademark protection? They have to be distinctive, capable of distinguishing goods and services from one entity to another. So registration of trademarks with the trademark registry provides exclusive rights to use the mark and prevent others from using those marks. So basically, it's a negative right. So trademark registrations in India are valid for 10 years and can be renewed indefinitely. Trade secrets, confidential information. So it might be source code, it might be customer list, it might be competitive advantage. So trade secrets are protected under common law and basically under contractual agreements. Okay. So breach of confidentiality agreements or misappropriation of trade secrets can be challenged through civil remedies. So trade secrets, what is the duration? So trade secrets can last indefinitely as long as the information remains confidential. So industrial design, semiconductor integrated circuits layout design act are some of the what do you call it, information intellectual property rights, which are important from the perspective of information technology law. So enforcement, when it comes to actually previously it used to be with the whole concept of tribunal reforms, rationalization and conditions of service ordinance of 2021. It has abolished intellectual property appellate board, and the pending cases are actually before the commercial benches of the various high courts. So basically, enforcement actions which are related to information technology would be injunctions, damages, other remedies to protect the rights of IP owners and prevent infringement. So IP disputes are considered commercial disputes by the virtue of Commercial Courts Act 2015. So, and these commercial disputes are heard at high courts known as commercial benches, which function under a very strict timeline for speedy disposal of suits. Okay. So the hearing of interim application in the initial stages of a trial is regarded as the deciding factor in achieving the objectives of infringement suit. So information technology, IP rights are essential for protecting innovations, fostering creativity, and encouraging investment. Okay, so this is what it is. And understanding and effectivity, utilizing IPR frameworks are crucial for businesses to safeguard their assets and remain competitive in a digital economy. So when you talk about the other facets which need, highlighting is data protection and privacy. So there are critical concerns worldwide as digital technologies continue to basically permeate into all the aspects of our lives. So various countries and regions have enacted laws and regulations to safeguard personal data and ensure individual privacy rights. So GDPR is one example which I've said about data protection. So what does it actually, what are the key provisions which are there? So basically, individuals have rights as the right to access, rectification, erasure, and also it talks about data portability. So it also talks about something called data protection impact assessment. Now, what exactly organizations have to do a DPIA? So what exactly is a data protection impact assessment? So data protection impact assessment is basically, it basically describes a process designed to identify risk arising out of a processing of personal data and to minimize this risk as far as the earliest possible. So data protection impact and assessment basically are important tools for negating risk or for demonstrating compliance with GDPR. Another facet which comes to is data breach notifications, which you must have heard quite a lot about it. Actually, most of the organizations actually always come out with this kind of notifications when they have to notify either authorities or affected individuals of data breaches within a fixed period of time. And there are certain penalties which are actually levied if there is actually a non-compliance. And it can be, I mean, especially by GDP, European law is concerned, the penalties can rise up to something like 20 million euros or 4% of the organization's global annual turnover, which is a huge amount. So when you come, that is the European Union, when you come to United States with regard to data protection and privacy, it does not have, a single comprehensive law like what you have it in EU, like the GDPR Act. Okay. But instead it has something called Health Insurance Portability and Accountability Act. It's called HIPAA short form. And you have certain things, and it is much more related to health information and patient privacy. So you have something called Graham-Liley Act, which is also known as, in short, GLBA Act, and it requires financial institutions to safeguard consumers' personal financial information. You already have mentioned Children's Online Privacy Protection Act, so it regulates the online collection of personal information from children. You have the California Consumer Privacy Act. So basically, it grants California residents certain rights over their personal information and imposes an obligations on businesses handling the data. So various other countries, whether it's Canada, South Korea, uh, they all have individual laws which actually, entails data protection and addresses privacy concerns. So there are certain other privacy or international frameworks which addresses, like you have certain things called APEC Privacy Framework, which is Asia Pacific Economic Cooperation Forum to facilitate cross-border data flows while protecting privacy. You have this Convention 108 plus, an international treaty for the protection of individuals with regard to processing of personal data overseen by Council of Europe. You also have Asia Pacific Economic Cooperation. It's a voluntary certification program for organizations to demonstrate compliance with privacy standards. And now, when you come down to India, you have this Personal Data Protection Act, which aims to provide a comprehensive, framework for data protection in India, including provisions for data localization, cross-border data transfer, and individual rights. So huge, kind of law which would take into foray, data protection and the complex frameworks of privacy and an immense challenge to regulate, data flows. So also when you look at artificial intelligence, Internet of Things and big data, they pose tremendous new challenges to privacy and data protection, especially in a country like India, where actually, data is the kind of population which we have and the kind of data which is being generated, whether it's actually, digital transactions or even for a fact, the health data, or it can be any other data. It's very, very important. It's still, we are, the whole concept is still being addressed by an act which is, meant for an age which was standalone. So that's another facet which comes to, interoperability and consistency among different actors. So this is another thing which comes into when you're looking at globalization. How does it actually, affect this when multinational corporations are actually operating in nation states? So collaboration is going to be very important. So basically, data protection and privacy are going to be fundamental rights that require robust legal frameworks and international cooperation to address challenges faced by technological advancements and globalization. So prior to actually the Data Protection Act, which India is going to come out, I think so it's going to be operational from July onwards. So still the information technology, reasonable security practice and procedures and sensitive personal data and information rules 2011 are still operational. So basically these rules were introduced under the Information Technology Act 2000, and it provides guidelines for the protection of sensitive personal data or information. So it talks about basically personal information related to passwords, financial information, health conditions, sexual orientation, biometric information. So it mandates this whole, entities collecting sensitive personal data or information. They must implement certain reasonable security practices to protect the data from unauthorized access, use, disclosure, or destruction of data. So Aadhaar Act 2016. So basically it addresses data protection concerns related to the collection, storage, and use of biometric and demographic information. So the act basically it also includes provisions for the protection of confidentiality of Aadhaar data, and it establishes penalties for unauthorized disclosure or misuse of Aadhaar information. Now you have certain sector-specific regulations meant for banking and financial services, health sector, telecom sector, and the Digital Personal Data Protection Act, which is going to be there. So basically, the act, it is came out of the Personal Data Protection Bills of 2019-22. So and numerous amendments later on, whether it entailed about data localization, transparency, or compliance intensive. So basically, the bills had to be withdrawn by central government, and this kind of right to privacy, which was given impetus, was only after the Supreme Court and Justice case Puttaswamy versus Union of India upheld the right to privacy as a part of fundamental right enshrined under Article 21 of the Indian Constitution. And it had suggested the central government to put in place an act regime for protection of personal data. So basically, what is the objective of this act? The primary objective of the act is to establish a comprehensive framework for the protection and processing of personal data. So the act basically shall apply to processing of personal data in India, including both online and offline, digitized offline data. So basically it talks about digitized. So if it's a form which is hand-filled, I don't think so it is applicable out there, and shall further extend to the processing of such data outside India relating to the offering of goods or services in India. So the Digital Protection Act or Digital Person Protection Act, it talks about data, it talks about processing of personal data, it talks about consent, which is the most important thing actually. So the consent has to be free, it has to be specific, it has to be informed, unconditional, and unambiguous. So a notice has to be issued as per Section 5, must be given by a data fiduciary before seeking consent containing details about the personal data to be collected and the purpose of processing. So again, it comes down to the aspects of definition of data fiduciaries, data principles, and what is processing of data, what entails that. So rights and duties of data principles, whether it is to obtain information about processing of data, whether to seek correction or erasure of personal data, nominate another person to exercise rights in the event of death or incapacity, for any grievous redressal, withdrawal of consent. So all these, facets are actually incorporated in this act. It also talks about obligations of data fiduciary, what it has to do. So while processing the personal data is only for which the data principal has given the consent. So, or if there is a deemed consent, when an individual does not indicate to the data fiduciary, so it is termed as a deemed consent, or for certain legitimate uses. So it also talks about certain exemptions which are there, which is, in a sense, the obligations of data fiduciaries and rights and duties of data principals are inapplicable in certain specified cases, prevention and investigation of prosecution of offenses, or processing for the purpose of ascertaining certain financial information, assets and liabilities, or by the state or any other instrumentality of the state in the interest of security and public order and necessary for research, archiving, or statistical purposes, setting up of a data protection board of India. So basically the appeals would like to telecommunication dispute settlement and appellate tribunal, and it talks about penalties, and so basically when you look at this whole concept of data protection and this thing, the act is quite comprehensive. There are certain aspects in which actually it basically, there is a criticism in which actually there is a state overreach when it comes to protection of personal data. So that's a different aspect in which actually on certain exemptions which are provided to the state, in which actually it can strike down aspects on which the rights are applicable, or the watering down of the Right to Information Act, which is there. So a public information officer can refuse to actually part with certain information if it entails to be a private information. So when you look at this whole gamut of personal data, uh, there was a long-standing needs in the context of increasing internet usage, data generation, cross-border state, trade. So the act which is there, which is the forthcoming act which is there in India, it tries to balance the modern data protection with, there were a lot of post-draft consultations, and they have taken into it. It's not as stringent as what's GDPR is of European Union, but it's a step in the right direction. But I still feel on a very personal note that kind of a state overreach is very dangerous when it comes to personal data, and when it comes to things in which actually more or less state itself acts as a kind of surveillance instrumentality. So this is one in which and why it is important is actually data protection, because that's basically in which if your data is protected, the whole ecosystem in which actually this country is operating is going to be protected, and that's very paramount for such kind of information protection. If you want actually you want to foster economic growth or innovation or digital inclusion to take place in this country. So when you talk about other aspect, which is cybersecurity, now this is one area which is just too wide. So, and that itself is a subject in which you require to actually really deep dive into this whole concept. So this constant proliferation of communication, commerce, critical infrastructure management, and government operation. So it's a multifaceted realm of cybersecurity. And when you talk about actually the basic importance of cybersecurity, it's actually you constantly hear this kind of popular culture narrative about malicious cyber attacks, data breaches, to espionage, cyber warfare. So it basically it extends various sectors and facets of modern society. So that's where the importance of cybersecurity is. It's about protection of data privacy. It's about preservation of trust. It's about safeguarding of critical infrastructure, whether it's related to power grids, transportation networks, healthcare facilities against cyber threats, and that could definitely disrupt essential services and undermine national security. You must have seen a lot of popular culture movies. I don't know, actually, 80s, we had a thing called War Games, you had Sneakers, and off lately, you had a couple of movies in which actually, rogue actors or rogue state actors or individual lone wolves would act to bring down certain critical infrastructure. If you are actually a huge fan of late James Bond movies, you must have seen those kind of facets in which actually individuals play a pivotal role, in which actually you can come down and destroy certain critical infrastructure, whether it's related to airlines traffic, or whether it's related to national grids, power grids, transportation networks, so or even stock exchanges. So prevention of financial losses. So protection of businesses or financial institutions and individuals from economic losses. Protections of intellectual property. That's another saying, whether it's proprietary information with related to copyrights, trade secrets, creative works. So challenges which are there is actually, and why cybersecurity plays such a dynamic role, because it's basically the whole facet of cybersecurity is driven by constant cyber threats and the complexity which is there in the digital landscape. When you talk about sophisticated cyber threats, basically the kind of tactics, the kind of social engineering which is being adopted, the techniques, procedures, leveraging malware and exploit kits to circumvent cybersecurity defenses. Also, another aspect is there actually when you look at a country like India, where there is a huge digital divide, in a sense, especially when you look at our own fellow professionals, there is a huge digital divide. And when I talk about digital divide, I'm not only looking at the kind of facet in which you're merely a user of actually digital devices. You have to be very, very, aware of the functionality of devices, the kind of network infrastructure which is there, rudimentary understanding of programming languages, rudimentary understanding about actually operating systems, or uh, domain name systems. So all these facets are there, and in a country like India, there is a huge, huge, huge divide. And basically, it you expect a kind of awareness and training which has to be there. So they remain unaware of cybersecurity risk, and some of the organizations which are especially SMEs, they're unaware of certain best practices, and it leads to vulnerability when it comes to these kind of threats, and especially from human error, negligence, lack of cyber security. That's one thing in which actually sharing of passwords, actually keep on hearing OTPs, and then you constantly, there's not a single day passes in which you haven't heard about instances in which actually people have lost a lot of money, either from bank accounts, or their digital devices have been compromised or hacked, or there are certain social engineering mechanisms which are there in place, and there people are not aware of those things. Another thing is which actually comes with is the complexity of the digital infrastructure. So when you look at Internet of Things and devices which are there, whether it's handheld devices, whether it's actually the watches which you're wearing right now, it's constant barrage of data which is actually being sent to and fro. It's a two-way communication system in which actually it's unending, actually. And basically the kind of data which is there, it amplifies, it basically acts as an amplification system in which actually you are prone to certain attack, and it surfaces from time and time again. So it's very important to actually secure those kind of devices which are connected, because these are to and fro devices, and certain resource constraints. I mean, with limited budgets, and the kind of cybersecurity talent which is there at present. I mean, and please understand, a lot of people who have been trained and who have not augmented, or who have not actually scaled up the kind of knowledge systems which are there prevalent during this period of time. They were our techies, for a matter of fact, who are trained on an 8088 or 8086 platform. It's very difficult for them to really actually scale up and understand the kind of complexity and the kind of network mechanisms or the network effects which are there at present. So person who has learned and has not scaled up during 90s and has not been a student for life, it becomes a very, very difficult uh, you know area for him to actually focus on, especially with regards to cybersecurity. So constantly, organizations themselves have to strive to implement, robust cybersecurity measures and maintain cyber resilience. So, and constant regulatory compliances which are there. So, and cybersecurity is an evolving landscape. So basically, what do you actually have those strategies, which is you can utilize artificial intelligence and machine learning, actually. So that is what most of the uh, significant data platforms which they are utilizing right now. So, but I don't think so that itself is enough, actually. When you look at takedown notices and things, still actually there's room for improvement. Then there is a concept called zero trust architecture. Now, what do you mean by zero trust architecture? It basically advocates for a least privilege access approach, in assuming that no user or device can be trusted by default. This is what it is. Certain users are given super user access, certain users are given normal user access. So basically, any user or any device which is getting connected, it is not to be trusted by default. So that is called a zero trust architecture. And it minimizes the attack surface and strengthening network infrastructure. See, please understand one thing when you talk about information technology law. It is actually a mix of regulations, policies, best practices, standard operating procedures, all these things. When you look at this aspect, it's not singly you can address those situations of data breaches, or user content, which is actually, defamatory, just by addressing this kind of thing by way of a legal thing. It has to be a multifaceted approach. You cannot have this single thing. So just to not to digress, we come back to the topic. Okay, so you talk about cloud security. So with the migration of data and workloads to cloud environments, now this is another one area in which actually encryption, identity, and access management becomes very important when cloud workload protection platforms are essential for security applications or cloud native applications and data. Now, cyber threat intelligence. Now, this is another thing in which actually it this kind of intelligence which is there, if it can be identified, you can mitigate cyber threats by either gathering, analyzing, and sharing actionable threat intelligence from various sources, including open source feeds. There is a thing called dark web. You keep on monitoring dark web. Uh, I hope actually some of the people I'm talking are aware of what is a dark web monitoring and certain industry partnerships. Now, cybersecurity governance and risk management. So effective cybersecurity governance frameworks, risk assessment methodologies, and cybersecurity risk management practices are critical for organizations to prioritize investments, allocate resources, and manage cybersecurity risk effectively. So when you look at the legal measures and challenges which are there in India, uh, cybersecurity has emerged as a critical concern in India, given the the kind of proliferation which is there and the kind of impetus which we are giving to digital India. So, but basically, when you look at uh, the national context, uh, it's always it boils down to one single act, and that is Information Technology Act 2000. So when you look at India's cybersecurity laws and regulations, as I said, the major law which comes to foray is the Information Technology Act. This is the landmark security law, which was devised during the 2000, and it was enacted by the Parliament of India and administered by Indian Computer Emergency Response Team, and it's basically to guide Indian cybersecurity legislation. It also protects e-governance, e-banking, e-commerce, private sector, among many others. So, and as I keep on reiterating that India does not have an exclusive unitary cybersecurity law. It uses the IT Act and multiple other cyber, sector-specific regulations to promote cybersecurity standards. Okay, so I will not deep dive into the concept of actually Section 43A, which actually, having that organization should have reasonable security practices and procedures to protect sensitive information from being compromised, damaged, exposed, or misused. 72A of the Information Technology Act, any intermediaries or persons that disclose personal data without owner's consent, that is are punishable by imprisonment up to 3 years of a fine of 5 lakh or both. So constant amendments have taken place, whether it's the Information Amendment Act of 2008, or in which actually cybersecurity measures and forensics were given much more impetus. So and importance of requiring intermediaries and body corporates to report cybersecurity incidents to CERTN, and establishment of a legal framework for digital signatures, recognizing regulatory intermediaries. Then there was the Information Technology Rules 2011, which I've highlighted previously, and so all these. There was a national cybersecurity policy which was 2013, which talked about the kind of security framework for public and private organizations to better protect themselves from cybersecurity threats. Then there was, national cybersecurity, I think so, the IT rules of 2021, which is actually, which is going to replace the 2011 IT rules with regard to intermediaries. So it's a new amendment which aims to allow ordinary users of digital platforms to seek compensation for the grievances and demand accountability when their rights are infringed upon. as well as institute additional due diligence on organizations. So there are changes to privacy and transparency requirements for intermediaries in the 2021 rules and IT rules, and it requires intermediaries to inform users about rules and regulations, privacy policies, and terms and conditions for usage of its services. It requires intermediaries to designate a grievance officer that can address and resolve complaints about violations of IT rules. It also has an online grievance portal established by the ministry within 3 months of the commencement of the rules. So that was what was actually during that period of time. And it has a three-tiered grievance mechanism consisting of a level 1, which was self-regulation by the applicable entity. Level 2 was self-regulation by the self-regulating bodies of the applicable entities, and the oversight mechanism by the central government. So a three-tiered approach which was there. And the new one which was there is the Intermediary Guidelines of Digital Media Ethics Code Amendment Rules 2023. So this is basically an amendment in which it talks about, fact check units, and it talks about online games, what are money games. So all these rules have been faceted, and you have this kind of FCUs which are there. So basically it entails that, what was not previously under the facet, the gaming sector is now going to be a part of it. Even social media sites or news sites which are operating in the social media domain will have to have a fact check unit. And again, there is a three-tier mechanism which is there in place. So, and another aspect which comes in actually this kind of deep fakes. This is another facet which so government has also come down with a kind of an advisory which is there. So basically, what are deep fakes? I presume actually everyone understands what are deep fakes, and you've seen most of the deep fake videos which are, so it creates basically a delusion with the use of deep learning AI and certain photo enhancing techniques to make images of fake events. So convincing deepfakes so far is actually, a lot of luminaries or important people have been, victims of such deepfake attacks. So the kind of misinformation which is there, so deepfake calls it out. So Ministry of Electronics and Information Technology has also issued a secondary advisory, which talks about as a major violation, and it talks about harm to women. And the platforms have to actually immediately bring down those kind of images or videos which are take down notices, and immediately actually stop further spread of those videos or images. And the government notice also talks about 66D, which is actually punishment for cheating by personation. So all these facets which are there, it's a multifaceted approach which is there. And also you have this National Cybersecurity Strategy 2020, and you have this concept called KYC, in which actually processes which are used worldwide and mandated by Reserve Bank of India in tracking and monitoring customer data. So all these things would entail a kind of a cybersecurity framework. So in which laws, advisories, policies, strategies have all formed a multifaceted approach within that framework. Okay, so KYC compliance is very important. The Reserve Bank of India Act of 2000, Amendment Act of 2018, which also talks about standards to equalize security frameworks of banks and payment operators. So mandated banks to create and present the cyber crisis management plans into foray. So, and it requires banks to implement mandatory breach notifications, in which urban cooperative banks, and they have to report it within 6 hours. And this is another thing which is actually there. I mean, most of the data breaches or whatever is there, you have to report it within a period of 6 hours. This is very, it talks about those facets which are there. And I think so. It's quite daunting, actually. I try to give as much as possible, which is there. So, in a sense, so yeah. Anyway, not to digress or not to lose this thing. So the 6-hour data breach reporting deadline. So the newest regulation which is there, the certain addresses cybersecurity reporting mandating all Indian companies, service providers, intermediaries, data centers and businesses to report identified cybersecurity incidents and data breaches within a 6-hour deadline. So then there is a thing called national. These are, certain bodies which are there, which are part of cyber security. CERT in is one body which is there. Then there are certain is actually computer emergency response team. Okay, so there are other bodies which are actually part of this process. Okay. So there are many different regulating bodies which are there. So I will not deep dive into each and every one of them. So rather than actually, go into this kind of exercise, I think so we will curtail it down at this, level, because I think so it's getting quite daunting even for me to actually go into the thing. Maybe down the line, maybe in the next era, we will actually look at cybercrime and data breach notification laws, and take it forward. Maybe I break it down into a second lecture. I think so. I've deep dived quite a lot. So I would like to end it out here, if you don't mind, and I'm ready to take questions. So we'll go into this topic later on as things devise, and we'll take over cybercrime and data breach notifications later on.
Sir, one participant wanted to know, can you shed light on the Paytm matter? What actually went wrong?
What actually went wrong is the kind of compliance which is there. Understand one thing, lot of Indian, and this is what actually we'll be talking about later on. What compliances needs to be done, Paytm has not done that. The kind of because it's a lot, and it takes a lot of time to actually delve into it. But as I said, when you look at the cyber infrastructure or cybersecurity facet, you have a lot of compliances, data breaches to everything, and Paytm was quite laggard when it came down to actually all these facets about complying with laws and timely reports which have to be generated. It was not doing that. So that is another aspect about it. Again, PMLA and all these laws which are there have played a major role when it comes down to these kind of financial companies, and they have not been quite up to date when it comes to compliances of laws. So this is one area in a nutshell which I can share about it. So compliances is very important for most of the companies which are operating in the digital realm. Okay, so if you are not complying with laws, whether it's you talk about blockchain companies or cryptocurrencies or everything, even cryptocurrencies is facing the same problem. Actually, most of the exchanges, they have not understood the concept about the RBI, which came down with the thing that it has declared virtual digital assets. So that's another thing which is there. So most of the compliances are not being done. So what permissions they had been given, they have not been actually in compliance with those things. So in a nutshell, I can say that much. I will not actually dwell much more into it at present. And because in the next lecture, I'll be taking it on, especially when it comes to blockchain, fintech industries. We're taking examples of that during that period of time. So I think so I've addressed this. So maybe we can go for the next question.
Okay.
So, any update regarding choosing cyber law as a career,
Cyber law as a career? Yeah, of course.
cyber law practice as a career? Anything,
As
pros and cons?
I told you, cyber law is not something actually. See, the problem is when you look at as only in terms of a career approach, means going to courts or going to things. I don't think so. That's a right approach, because you're looking at platforms. You're looking at actually kind of strategies to be in place. As I said, it's a multifaceted approach. Career in information or cyber law as such, just from practicing in courts in terms of litigation, I don't think so. It's more, you can't be a sole breadwinner regarding that. But if you are in an advisory capacity to corporates, you have a team in place which is actually, they understand forensics, they understand, especially forensics, I'm talking about digital forensics. When you understand SOPs, when you understand policies, when you understand all these things, so that would be tremendous. So a career in cybersecurity law, I would rather use the word that, not information technology law, but cybersecurity law is a huge thing. It's definitely a very, very upcoming field, whether you are looking at blockchain technology, whether you're looking at applications of blockchain technology, contracts, digital contracts, or even currencies. Bitcoins, or Bitcoins is one of the blockchain currencies which are there, cryptocurrencies. So it's a huge thing. I mean, it's artificial intelligence. It's a huge facet which is going to be there. So when you look at cyber security law, or it's a huge career. So definitely it's a yes, but you will have to have a very different approach, not solely from the perspective of litigation.
Okay.
So
IT background mandatory?
IT
IT background?
IT user, yes. Background courses. See, I mean, this kind of concept for technology which is there, you could be a person who's adamantly, interested in technology. In a sense, in computers and devices and all these things. So there's no harm in that. I mean, to drive a car, you don't really have to understand the workings, but there are lots of people who are not automobile engineers, but still they are petrol heads. You understand what I'm saying? They know the intricacies of the workings of the whole system. Same thing is with people. I mean, a lot of people are not techies by what do you call it? Academic degrees, but they are techies in terms of usage of technology. They understand everything. I mean, technology is something. It's your prerogative which you actually take it forward. You want to learn C. You want to learn Perl, you want to learn languages, you want to go into actually deep dive into networking systems. There's nothing stops you to understand that. But yes, a prerequisite, I don't think so. But a rudimentary understanding of technology, yes. A good liking for technology, yes, definitely. That wouldn't harm you. But if you don't like digital technology, I don't think so. That's the right career choice for you. Okay.
Okay, got it, sir. Thank you.
Welcome.
Okay, so a participant is asking, what are the safeguards against cyber attacks from extraterritorial jurisdictions? For instance, we have experienced in the past cyber attacks from Pakistan. So, what is the measures taken by the government?
First thing, I don't want to sound very political. First, yeah, it's a fact. If you have a cyber attack, and if they are able to attack, the problem is we have a very, very weak infrastructure, critical infrastructure reporting mechanisms in place. And second thing, we don't have very good firewalls. We don't have proper mechanisms in place. So the problem is not only from the legal perspective, it's also from the technological perspective, policy perspective, and also in terms of readiness. When you talk about cyber, see, you don't have this kind of lone wolf system anymore in place. It's a concentrated attack in place in which actually the state actors themselves, take over the functioning of crackers, or trying to, bring down a critical infrastructure system in place of a country. So if you say, certain actors are attacking and they are successful, I don't know actually. They have been doing it, we do it. There's nothing. We are not actually, even our country is doing a lot of internal surveillance and things like that. So I don't want to delve into it. There are a lot of software and a lot of issues which are transpired in the last couple of years, and I don't need to highlight that. Everybody is aware of that. So it's not only the state actors from outside, but also your own very protector of your individual rights. They have to be taken into consideration when you look at this aspect. So this is a kind of a question which you should be asking the government policymakers, not the person who's a lawyer. But yes, if you say from a perspective of other state actors are able to actually bring down your system and having concentrated multifaceted attack on your critical infrastructure like cyber warfare or anything, speaks we are not ready for that kind of thing. So information war in the 21st century is very important to have all these critical infrastructure protection mechanisms in place. So anyway, we'll be addressing those things in the next lecture. So I would say that, and as I told you, this kind of lecture is not something which is on its own. It is a series of things. So deep diving, unfortunately, I somehow was not able to actually keep the time frame into equation. I thought I would be able to, but I think so. Emotion got better of me. So anyway.
So the next question is it ethical on the part of websites to use cookies?
Ethical, technologically, yes. Ethically, in a sense, you've been using cookies since HTTP. No harm in that, but and there is not much of information when it comes to cookies. Okay, so you're confusing it with it, because without cookies, you won't be having those things in place where you will be able to actually that it would tell you what site to visit next, what kind of video to watch next. So these kind of things would not actually, and how many people have been coming down to whether you're a frequent visitor to this site or not. So these kind of things are important when you look at, the perspective of a commercial organization. Maybe not for the individual, but how do you actually, to better your services every time you can't come down and have a customer feedback form, right? If you visit a site. So cookies are a much better way of in which, and you can actually go into an incognito mode. Who stops you from that? So you can have this kind of technological system in place in which you can actually bypass those things. And the new data protection and all these acts are actually, all the sites have to actually tell you what kind of cookies and what kind of information they're taking from you when you're visiting that site. So that is in place. So GDPR and all these things are absolutely clear on those aspects. So laws are in place. It's only when you go into the dark web, then things are taken for granted. So be very careful when you visit there. Use proper systems, use Tor network or whatever it is when you're going down there. So be careful. Don't visit if you're not tech savvy. So be careful about that. So yeah, can we go on to the next question? If successfully,
Yes, sir.
yeah, sure.
So, participant has done his or her career in data analytics. Now, in the third year, final year of 3-year LLB course. So,
Okay.
wants to know what are the avenues in tech law. Can the participant explore policy enforcement?
Yeah, of course. Data analytics and law, it's a huge, so you can go into the foray of, trade and technology. No, absolutely. It's a great combination. And that's going to be the future. So absolutely, it's a great foray if anybody is looking at things. Analytics will always help you in understanding. Statistical basis will always help you to understand things. And of course, a kind of a mixture of, but as such, you'll have to have a rudimentary understanding of law. Unfortunately, in India, we directly jump to, teaching of barracks. That's the problem. So once we go into the law school, it's the problem is actually we just stick to barracks. We don't go into the kind of nitty-gritties which is there beyond the law, understanding certain important cases which are there. We just directly go to sections and kind of this thing, which was not the real intention for understanding law, because all law, everything are basically social constructs. So if you don't understand social constructs and you don't have this kind of philosophical understanding of what mechanisms are there in place, it's very difficult for you to really understand. Barracks are not going to be resolving your thing. You might know all the sections by heart, but that would not make you a better lawyer, or would not be able to actually not be able to address the challenges which are there going to be in future if you don't have a philosophical base. So yes, analytics and law, a great combination. So best of luck. Actually, if you are looking forward towards a career in policy making or even in tech area, definitely it's a great thumbs up. Definitely a yes.
Thank you so much, sir, for such an illuminating talk. See you
Welcome, and
in the
really
next
appreciate it.
session.
Thank you.
Thank you, sir. Bye, sir.